Welcome to the Injustice Podcast. I'm your co-host, Jay Farrow, and I'm here with
Janine Davis.
And we're here today to talk about an article that I saw in the Florida Bar News relative to modifying how lawsuits are going to move forward in the future based upon the backlog that happened during COVID. And actually, I was just so shocked to see it, because what the article was saying is that that there's a conversation about creating a modification to the civil rules of procedure that govern how lawsuits happen in order to expedite the process. And while that sounds great, part of the concern that I had, and that was actually in the article, was that this would advantage the people with that have already have the advantage with a lot of money, a lot of lawyers, and seemingly endless amounts of time to jam up the process, as it were.
So, talk a little bit about what the article consisted of. In other words, like, what points of concern? How are they jamming it up? Because I think that our viewers would really like to know that.
All right, let's just talk about what happened during COVID. There was, and everybody knows, there was shutdowns, there was lockdowns. People stayed at home, and to the point of March of 2020, all of the hearings that I would have to go to, barring some exceptions, happened in person. When the shutdowns happened for the first few months, the court system didn't know how to handle that.
Right.
And the court system started to adjust by allowing attorneys to appear via Zoom for all different types of court hearings.
Right. And that is still ongoing.
And that's still ongoing, but now there's a hybrid where there's some hearings that are live, trials that are live. I was at a oral argument the other day in an appellate court that was live. But what had happened was, if you can imagine, the hearings are one part of a legal case. When I say hearings, when you file a lawsuit, there's going to be little fights over discovery or what types of evidence can be admitted. Those types of hearings can be handled by Zoom. The thing that stopped was trials.
Right.
And jury trials in particular. Because if you can imagine, not only were people trying to social distance in courthouses that are quite small, the state
to begin with. Yeah.
Right, to begin with. So trials started to get continued. And for about a year and a half, you had starts and stops.
Right. So when a trial is continued, what it means is that it's being pushed back.
Yeah. And there's a saying in the law, justice delayed is justice denied. And so I'm not just talking about the civil court system. I'm talking about the criminal court system.
Right.
And fast forward to 2022, the Florida Supreme Court, and we have a law practice, and I am one of the attorneys in our office, and
I am the client attorney liaison, a non-attorney, albeit, and I am responsible for the running of the office and also the business portion of the law practice.
But more importantly, she sees the law from the lenses that I no longer see it, like as far as the inequities, which is why we created this podcast, to really discuss what's happening in the trenches in courts, so that people can get an idea of actually in real time what they can expect from the current judicial system, because you're going to be shocked to see how not just inefficient, but how behind we are. And
correct, and also how slow it is, right? It's very arduous. It can be for a client, it can be a very arduous process, because they're expecting that the hearings will happen fast. The law doesn't work like it does in business. I think that in the business world, things are much more fast paced. In the law, one of the things that when I integrated into this world that really surprised me are the amount of delays in things and the slow pace at that things happen, because you're dependent on the judge's calendar, you're dependent on opposing counsel's schedule. So there's so many different things to coordinate that things don't happen as quickly. And I think that this, on a psychological context for a client, can be very taxing, because it feels like hurry up and wait. And yet there are so many different things going on in the background until all of those things are happening. So it's a very interesting industry, but it does have a lot of delays. And so I think that what you're speaking to with this Florida Bar article is that they're trying to remedy that, but they're doing it, in your estimation, in a way that is not exactly fair.
Well,
or continues to not be fair.
The niche that we have in our law firm relates to partnership disputes, and most lately we have seen in our practice that as COVID is lifting, so to speak, and companies and some partnerships are starting to thrive again. Some of the partners that we represent are being edged out of their partnerships because when money starts to flow. That's when you really get to know your partner, because everybody can trust, and everybody's on the same team while no one's making money and
right. Once people are, if everyone's broke, everyone's in it together. But once that money starts flowing, and that's when start looking at your partner a little sideways, like, what are you doing?
Right. And
what is so and so doing?
And a lot of times we see that in partnerships you have like the person with the industry knowledge, the person that puts in all of the sweat equity, and then there's the person with the capital. And whether you're the person with the capital or you're the person with the sweat equity and everything, either or, you could be in this position where you are you've been working with your best friend, someone you trusted for 5 or 10 years, and now you're being pushed out. So now you have number one, to face the fact that you may have to settle a legal dispute. But then what are your options? And what this particular episode of the Injustice Podcast is about is what are the realities that COVID has had on the judicial system, and who does it advantage? And 100% it advantages the defendant in litigation, because during COVID, because of the shutdowns, there was delays.
Right.
Trials were pushed off. And if you're the person that's seeking judicial relief and you're the plaintiff, and let's say you're right and you've been stolen from or ripped off, or you've been edged out of a partnership and you're starting to lose things, it was advantage to the bully, to the narcissist,
to the taker.
But now I read this article, and it presents me to two things. One is how the Florida Supreme Court tried to remedy the issue.
Okay, which is how
they attempted to get, and they, to a large part they did, require all the trial judges in Florida to come up with a case management plan for any particular case, which basically gives you a skeleton of, okay, on this date, you're going to complete this task. On this date, you're going to finish
Correct.
all of the depositions. And on this date, you're going to go to trial. Fine. But the realities hit the judicial system. The realities of the personal life. We're talking about the personal life of lawyers, causing delays. But it's also, there's so much grinding work that goes into a lawsuit. And we know, you talk to the clients. I mean, they think it's, here are my facts.
Correct.
And I'm correct.
I'm right. They're wrong. It's a 1, 2, 6 process. It's a slam dunk. And very rarely is that the case. And even if it were the case, the judicial system doesn't see it that way, and it doesn't practice that way. It's not a linear process. But bringing that back into focus with the article that you were discussing, how do you see that it continues to advantage let's say the guiltier party here?
I call him the bad guy.
Yeah, the bad guy. How so, Jay?
Well, number one is that from what I've seen, my experience is that cases are not moving how the Florida Supreme Court had hoped that they were going to move, because of how much backup there was and how many different spikes of COVID there was, that they were going to open courthouses, then courthouses closed again. Right. So it didn't lend itself. I mean, the idea was fantastic to get all of the cases in Florida on a case management track similar to federal court.
Correct.
But it didn't end up happening, as
Smoothly.
envisioned, I think, by the Florida Supreme Court. So there's a thought that there would be some type of modifications done to the rules of procedure. I'll explain that a little bit. Is that the rules of procedure provide for deadlines, timings, like when you can serve out a subpoena, when you can serve out discovery, when discovery is due. So they're talking about...
For people who are not familiar with the term discovery, discovery means that each side is exchanging information in order, of course, to discover information that is pertinent to advancing their side of the case in whichever form that comes. So it could be emails, it could be letters, it could be faxes, it could be, well, not so much faxes today. Faxes. I just dated myself. But it could be any type of information exchange, text messages. So that's what discovery is for people who are not familiar with the term.
So they were talking about these modifying the rules in such a way to facilitate cases moving on a faster track. And the flip side of that I was reading in the article was how that could advantage the larger firms. So in other words, imagine that you have a person that you're suing, and that they have the means to have 5 lawyers at a large law firm completely dedicated to your case. And they can get a lot of work out the door within a very short amount of time. And then on your side, let's say that you have, and not to say that more lawyers equal better justice, but the reality is that if you have a team of lawyers of 5 to 7 that are working on a case, if you had shorter times to finish things, like in other words, to get out discovery or to respond discovery, you have 7 hands, 7 times the people to be able to handle that and comply with these deadlines. Whereas lawyers with, let's say, smaller outfits with a couple lawyers dedicated who are completely competent, who would otherwise be able to function within the rules as they sit today, you're basically giving the advantage to the very wealthy.
The people who can afford the teams of lawyers.
So that could afford the teams of lawyers and could afford to keep up with that type of pace. And believe me, if they want to slow it down, they know how to slow it down. I mean, one of the things that we've been talking about on this podcast for a while is how broken the system is, because how overburdened the judicial system is. But you see it from your chair more than I do. Like you can from.
I really do. I often say to Jay, being a non-lawyer and a private citizen and a very proud U.S. citizen, there are so many things that don't make sense. There's so many times and instances where I see that even the judges are not following the black letter of the law. And to someone who is from the outside looking in, even though I work in the industry, it doesn't make any sense to me, because it should be that the law is the law is the law. And yet there are so many different things that go into it. Because at the end of the day, you have human beings interpreting the law or bypassing it completely, because they have what's known as judicial discretion, which means that they can bypass the law to sort of put in their 2 cents and rule in ways that they feel is correct. And that is very confusing to a lay person, because, when you look at the scales of justice, you literally have this being with a blindfold over her, and the symbol is that it's blind because the interpretation is the black letter of the law, and that's not at all what's happening in real life, which is what I think also creates such a disconnect between client and attorney and client and the judicial system. It's all well and good if you're on the side of winning, but even when you have facts and a case that should win, and sometimes it doesn't, because people misinterpret you as the plaintiff, or they favor the defendant for whatever reason that no one really knows. It's not as blatant. all of those things come into play, and it becomes a very complicated thing. So
add to that now that the Florida Supreme Court tells all the judges, not only are you overburdened and you have a bunch of cases on your caseload, you're going to move these things on a mandatory basis and get all of this work done, while you have, screaming, people like me saying, "Whoa, judge, this is the time that I need to take this, and we need to work these things out." To your point of talking about what the client's expectations are, and especially if you're finding yourself in that position where you have to use the legal system for the very first time, and you are right. Let's say I let you check all the list. This is exactly what happened.
Right.
This is exactly how much this person stole from me. This is exactly how much of the partnership that I own. You think and you should, but it's not this way, that you walk into the court system and it's like you file a complaint and the judge actually reads that complaint. That's not what happens. The judge actually doesn't read your complaint until the first hearing comes up on a motion to dismiss or some other type of motion that happens relatively, early on about the actual pleadings in the case. But just because you're saying all this, and even if it's a verified complaint, and the other side says no, well, the other side can say no all they want. And the thing is, if the other side is used to litigation and they're used to having lawyers do their thing, they know that they can make a calculated business decision to use the justice system to basically steal, because not only have they already taken from you, they're about to take from you a bunch of time and money.
Correct.
Which we
above and beyond what they've already taken.
This podcast is really about, like, how to use your own intentionality to be able to solve a business dispute without having to invoke the belly of the beast, like filing a lawsuit into the judicial system, especially now where there's conversations about how to. And I'm not saying that they're trying to do this like on purpose, like there's a conspiracy.
Right.
But if you're going to modify the rules, to basically put more pressure on getting cases done faster, than the smaller firms that you have 1, 2, 3, or 3 lawyers that are working on a particular case, as opposed to 7, are going to be very challenged to do in excellence what the other side could do. So it comes down to, you get the justice that you pay for, or you're innocent until you're proven broke. So when I saw this article, I was completely blown away. It's like it's enough that the Florida Supreme Court came in and said, "All right, everybody, the pigs got to go through the python somehow, some way," meaning the backlog.
Yeah. For sure.
Here's how we envision doing it. Get a case management plan and stick to it the best you can.
So conceptually, it's a really great idea, except that in practice, it's what Jay is talking about. That's how it translates into the real world. Because
the lawyers are so used to the way that things were working in state court, especially, and not having this type of scenario where upfront you need a case management plan and it's push. A lot of times, there's lawyers with a lot of cases and a heavy caseload, and they're great lawyers. It's just that they have smaller outfits, and now I don't want to say the little guy or the average Joe, but let's call it that for a second, are getting priced out, and now it's going to be procedurally pushed out of really the benefits of using the judicial system.
Right.
So when I saw this, I was like, this is a perfect topic for On Justice podcast, because it's just that if it wasn't bad enough before that we were talking about bad decisions. When I say bad decisions, like decisions that, like, you're 100% right on the facts, you're 100% right on the law, but that day, the person sitting on the bench didn't see it that way.
Yeah.
And that happens.
This is the toughest part.
And that's the toughest part to understand as a lawyer, let alone a client. Correct. And here's the thing. It's not like I'm blaming somebody. It's just the way things are. So the answer is, like, what do you do about it?
Right. And that's really, I think, one of the things that we give a lot of thought to. Right. And especially you're the attorney, I'm a non-attorney, but together we can think of solutions to create for people that are within the scope of the law only always. However, it's also being intentional about how to use the tools within the law. For example, the case management plan. That's a great example also. Even when we're in litigation, we're always talking about pushing a pre-suit mediation, pushing different things, pushing for a settlement. Why? Because ultimately, very few cases actually go to trial. So what happens is you're ultimately going to settle. Why would you not do what is most efficient and in your best interest 2 years before everything goes down the tracks? And at the onset, and get it over, get in and on and out with life.
Get in and out and on with life.
Get in and out and on with life. Because ultimately you're going to end up settling 2 years down the line, 2 years of attorney's fees, 2 years of aggravation, 2 years of time that you cannot get back.
If you take nothing else out of this episode, understand this. Like, COVID has completely changed the court system. Right now, everybody's trying to figure out how to do something about it, and there's just no really good answers. The thing is that most cases are not a whodunit, okay? Everybody knows who did what.
Correct.
All right? And in every single case, you're going to be required to go to mediation at some point during the litigation, and you have the power to do that even before you file the case. So I'm going to keep you updated with how the Florida Supreme Court and how the conversations are going about modifying the rules of procedure and cases, and how that's going to affect you, because this is one of the most important, critical things that we've ever even envisioned talking about on this Justice podcast, is that the justice system is about to break. As it's bent, it's about to break.
Yeah.
So, again, I'm your co-host, Jay Farrow.
I'm Janine Davis, and we want to invite you to understand that we're bringing these topics to you, but we're also bringing ideas to work within the paradigms. And so it's about innovation and moving things forward, even in a system that's less than perfect.